on the Daily Debrief. A political operative indicted on federal charges. Plus, a defendant refers to a missing family in the past tense. Does it connect him to their murders? Also,
his body just went boom.
Jurors explain why they convicted an Ohio woman.
She did it.
Of murdering her military husband.
Why did she shoot him?
This is the Daily Debrief for Friday, January 25th. Good evening this Friday night. Welcome to the Daily Debrief. A federal grand jury has indicted political operative Roger Stone on a series of charges stemming from the special counsel's investigation into Russian influence over the 2016 presidential election. Stone is accused of 1 count of obstructing proceedings, 5 counts of making false statements, and 1 count of witness tampering. The indictment accuses Stone of lying about serving as an intermediary between the campaign of President Donald Trump and WikiLeaks. WikiLeaks was publishing information said to have been obtained by Russian hackers from computers at the Democratic National Committee. Stone has long bragged about being close to President Trump and of influencing Trump's decisions. Former Trump campaign manager Paul Manafort also appeared in federal court today. Manafort's legal team disputes special counsel Robert Mueller's claim that Manafort lied during interviews and grand jury testimony. Mueller's office says Manafort lied about interactions with a Ukrainian operative connected to a Russian intelligence unit accused of hacking Democratic officials. Manafort's lawyers say Manafort provided information to the best of his recollection or simply did not remember certain details. Manafort spoke to Mueller's office 9 times and testified in front of a grand jury twice. Testimony in the case of a California man accused of murdering a family of 4 is focusing on forensics and money. Defendant Charles Merritt could face the death penalty if convicted in the killings of his business associate Joseph McStay, McStay's wife, and the McStay's 2 boys. Authorities at first wondered if the McStays fled to Mexico to avoid business debts, but a dirt biker later located their bodies buried in the desert years after they disappeared. That is when suspicions focused on the defendant. The jury saw images from the grave this week as prosecutors elicited testimony about the recovery of the McStay family's remains. A dirt biker, as we said, discovered the skull of one of the family members. That led authorities to the graves of the entire family. Authorities also recovered the sledgehammer suspected to be the murder weapon. They further found a cord believed to have been tied around victim Joseph McStay's neck. The biker who found the bones testified this week. Here is his 911 call.
I'm here on a motorcycle at the time the dump, and I found what looked like a human skull.
Can you give me a location?
Yes. Okay. West of the 15 and north of the stockpile where the dump is. But see, they actually just call the local sheriff and tell them where on a map. Because it's on dirt roads.
I understand, but I'm just looking for a starting point. And this is the local sheriff.
Oh, okay. Starting point. Start at the 15 north Starterwell exit.
Okay. Let's see, is it over by the landfill?
Yes. It's within, I'd say, about a half mile of that landfill. It's directly to the south of me.
Okay, so from the landfill, where are you?
Due north, approximately, I'd say a good 2,000 feet.
Okay. Did you find it in the landfill or just in a field out there near it?
In a field.
Prosecutors this week also played a police interview with defendant Chase Merritt. Here, he talks about the victim's finances. Remember, prosecutors say Merritt killed because he needed money.
Joseph doesn't have any enemies. Everybody loves Joseph. Everybody. He has no financial problems that I know of. I mean, him and I, things were tight over the last few months because of the economy, but stuff has been, over the last couple of months, things have started picking up. I know for sure that his bills are paid. I don't know of anybody that has anything to gain by Joseph being gone. I think everybody that I know has everything to lose. Everything. This business stems almost solely around Joseph. He does all of the sales. Dan's trying to send me some emails and trying to, we could try to salvage some of the jobs that are trying to send stuff back.
Now, the name Dan you heard there references Dan Kavanaugh, the man the defense is pointing to as an alternate suspect. The interrogation revealed further animosity between victim Summer McStay and defendant Chase Merritt. The animosity involved the tangled web of finances the defendant shared with the victims. Here, the defendant begins by mentioning victim Joseph McStay.
A super nice guy. I mean, he'll give you the shirt off his back. I mean, he'll do anything for you. And Summer's just the opposite. She's taking the shirt. Well, I don't know so much about that, but she won't give up anything. What's hers is hers, and what's hers is going to stay hers. And Joseph is more like, you need what? There you go. Oh, I mean, I've got, mine and Joseph's running tab is $10,000. He owes me $10,000. I owe him $15,000. If he owes me $5,000, I owe him $15,000. It just goes. And Summer never liked that because it was just always a running tab. If I needed money, I pick up the phone and say, hey dude, I need a couple of $1,000. If he needed something done, he picks up the phone. Hey dude, I need, we got it done. Whatever it was, we got it done.
There, the defendant discussed the financial troubles he shared with victim Joseph McStay.
We've been having financial problems for 6, 7 months, 8 months. Well, it's just, business has been, it almost dropped right out from under us for like 3 months. There was almost no sales at all, and that killed us financially. My heart attack didn't help much.
So you don't have medical insurance? You have to pay that out of pocket?
Out of pocket. I don't pay at all, and right now, actually, we're negotiating with the hospital that this is $107,000.
How much debt are you in?
That's it. I mean, I don't really owe a lot of because all of my bills, like when I buy stainless steel, stuff like that, pay cash for it. I don't really owe a lot of money except for the hospital. That's the big, and worst comes to worst, I won't be able to pay the hospital. I mean, I want to, of course, as my debt, but, I don't, in the financial situation we're in now, it's going to be iffy at least for a while, especially if Joseph doesn't get back pretty soon, my rent won't get paid at the end of this month. So that's not going to be fun.
Attorney Stephen Greenberg joins me tonight on the debrief to break this case down. So, Stephen, this is a circumstantial case. The big question is how the state is going to link the crime to the defendant. Did the financial information the defendant discussed in that interrogation push the needle one way or the other, in your opinion?
I mean, I don't think so, because what he said was he owed me money, I owed him money, we did things together, then jointly we had business problems. Killing this man doesn't solve his debt problems at all. It doesn't solve the defendant's debt problems. In fact, what happened is Kavanaugh ended up taking the money out of the business account. So the fact that he loops in Kavanaugh and he is having financial problems, the defendant having financial problems, I think actually helps him. If the defendant was having financial problems and he knew this money existed, why wouldn't he take the money?
Good questions. And, of course, Dan Kavanaugh, that alternate suspect that the defense is pointing to. What do you make of the defendant speaking of the missing family in the past tense at one point? Should jurors make a big deal about that, or is that just what a normal person would start doing mentally when a family up and vanishes and is gone for quite some time under mysterious circumstances?
It's a police interrogation. People are going to be naturally nervous. I think that you can have a conversation with someone and they can use words improperly. He doesn't do it repeatedly. I think it's just something that, they could try and make a big deal out of it, and they could say, oh, it's the great Freudian slip of the whole case. But that's not going to be enough, as you said, to move the needle, certainly not enough to move the needle to a guilty.
I would agree with that assessment as well, because I've seen people speak that way in missing persons cases. Okay, so these do seem like brutal deaths, however. Hammer blows to the head, the face, the jaw. That seems more like a crime committed by someone with personal animosity. Or am I wrong on that one?
No, I agree with that. I mean, if you're having a dispute with your business partner, you don't kill the business partner's entire family. And if you're going to kill people and you're going to commit multiple murders, typically you would use something like a gun, because you wouldn't, you can't use a hammer, I don't think, and kill people boom, 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 just in a row. So I'm perplexed by the whole thing. I can't wait to see what else they have.
Yeah, this is going to be a long case, 4 to 6 months. The prosecution is just getting started, even though they've only been in it, I say only a few weeks here. So you never know where things might go. Stephen Greenberg, we will check in with you with our next case after the break here. In case you missed it last night here on the Law and Crime Network, the premiere episode of Brian Ross Investigates will be shown on the Law and Crime Network immediately following this broadcast. The topic is the extent to which the Saudi government breached social media accounts and used the data to jail dissidents. The government's alleged actions came as the people of the Middle East perceived social media as a new platform for free speech. To what degree are social media companies responsible as well? That question and many more on Brian Ross Investigates, coming up at 5:30 here on Law and Crime. And still ahead tonight here on the Daily Debrief, jurors have been talking about their verdict against the Ohio wife accused of murdering her husband. Find out what key piece of evidence may have pushed the jury toward a conviction. That's after the break here on the Daily Debrief. Welcome back to this Friday edition of the Daily Debrief. New information about the verdict against an Ohio woman who took the stand and admitted she shot and killed her military husband. The case was filled with testimony about his sexual behavior and her suicide attempts. Wife Claudia Herrick disputed the state's theory of why she killed Air Force Reserve Major Carl Herrick. The state says Claudia drained Carl's bank accounts, sent his money overseas to her relatives, bought a gun with a laser sight, and practiced all before killing her husband. She then fled to her native country of Brazil. The real question was not who did it, but rather the degree of the crime. The state wanted to convict Herrick of aggravated murder with a firearm. That requires premeditation, and it carries a life sentence under state law. The defense, however, sought a voluntary manslaughter conviction. That charge would have required jurors to agree that the shooting occurred in a fit of rage. The sentence here is 3 to 10 years. The defense strategy did not work. Here is the verdict.
We, the jury, in this case, duly impaneled and sworn or affirmed, find the defendant, Claudia C. Herrick, guilty of aggravated murder as she stands charged in the first count of the indictment, dated this date, signed by all 12 jurors. As to the specification, we, the jury, in this case, duly impaneled and sworn or affirmed, find the defendant, Claudia C. Herrick, did, at the time of committing aggravated murder, have a firearm on or about her person under her control, brandished the firearm, indicated that she possessed it or used it to facilitate the offense, again, dated this date, and signed by all 12 jurors. Ms. Fowler, did I properly read the verdict of your jury? Anything further from the state?
No, Your Honor.
Anything further from the defendant?
No, Your Honor.
There, deputies took Claudia Herrick into custody. Sentencing is in a few weeks. Closing arguments, like many aspects of this case, were heated. The defense attacked the state's theory of premeditation and pointed to a romantic contact the defendant had outside her marriage.
Why did she shoot? Why did she come up with this entire plan for premeditation? The state told you in opening it was because he was leaving her. Now, if she was so afraid of him leaving her, if she didn't want a divorce, why, after she gets out of the hospital after her suicide attempt, does she go back on Match.com and start meeting another person? Why is she talking with Bruce Robbins? Why is she carrying on a relationship with him? if she's so upset by her husband leaving her that she's going to kill her. Now, Bruce Rogers. Interesting thing about Bruce Rogers is he was on the state's witness list.
Objection.
Criminal Rule 16 says I can clearly comment on it.
He was on the list and he wasn't called.
Right.
Don't comment on what he might have said.
He was on the witness list. State had indicated he was on their list. State knew about it, Mr. Rogers.
The defense then looped back to Herrick's decision to purchase a gun and to key testimony about the size of the bullets.
She tells you on the stand a number of things that the state doesn't dispute. She tells you, and we all agree, she went to the store and she bought a gun, .357 for Slugmasters. She lied to the person at the store and said she wanted it for protection. Yeah, she lied at the store, she wanted protection. You heard the person. If somebody comes in and says, hey, I want to buy this gun to kill myself, they're not selling them a gun. So she goes to the store and buys a gun. She buys ammunition for the gun. She gets laser grips put on the gun. She buys two kinds of ammunition, ladies and gentlemen, .357 and .38. Interestingly, the person at the gun store tells you .357 hollow points are what you use when you want to stop and kill somebody. .38s are what you use for practice. When you look at the report of Dr. Chappelle, and you'll have the report, and you'll remember his testimony, that the bullets they pulled out of Carl Herrick, the bullets they pulled out that killed him, were .38s.
Yeah, I object, Your Honor.
It's in the report.
During the state's rebuttal, one prosecutor loudly argued about the size of the bullets and their relevance.
I think you're going to find a report that says .38 caliber. That's the size of the bullet.
Objection.
Overruled. The jury will determine.
You have plenty of evidence about the loaded .357. You can look at the shells. That's the size of the bullet, and also the base of the bullet. Remember Slater, Martin, talking how a .38 can go into .357. There is not that much difference in the bullets. And remember Philo? He said it doesn't matter if you have a .38 or a .357, they're going to kill you.
I'm going to object.
Overruled.
He did not say that.
It doesn't make a difference. Thank you, Your Honor. It doesn't make a difference in this case whether she uses the .38 or the .357. She's buying all the ammo. She's going home with the gun. This man is leaving that house. He was on a flight, and she's talking to her boyfriend while he's on the flight. You didn't have any evidence.
Overruled. This is closing arguments. Proceed.
You have no evidence Carl was running around with anyone. Did you find another pathologist coming in this courtroom to say that Philo wasn't telling the truth? None. As Mr. Becker showed you, there's no self-defense, there's no insanity.
Objection. I've never raised any of that.
He didn't say there was one. He said there wasn't one. Go ahead.
Wow. Earlier in this case, the defendant took the stand and told jurors graphic details about her sex life with the victim. She said those issues and others pushed her over the edge.
Carl had issues in the bedroom?
Yeah, he was not able to perform without Viagra or without bondage or without something weird or me pretending to be dead. He would not get an erection with normal sex.
And you talked earlier in your interview that was played about a website called Hogtied.
Hogtied.
What was that website?
It's about sadomasochism. It's about bondage.
Okay. And would he make you do things he saw on the website?
Yes, but this also, yes he did. But this was all after we got married. He never hinted to me that he had any sexual issue or fetish. Is that called fetish? Fetish. I cannot say that word. Do you know what I mean?
Yes.
I never noticed before we got married. What I know is that he was very nervous about his penis. He had a lump in the middle of his penis that he said some woman, when he was deployed, he went to Germany. She sat on his penis. She broke it. he has this lump, and that turned into cancer. He was freaking out about having cancer, and he was freaking out about not performing.
Eventually, Herrick went on to describe the moment when she did pull the trigger. Attorney Stephen Greenberg still with us tonight here on the debrief. At least one of the jurors spoke after the verdict. One thing they apparently focused on was the laser sight Claudia Herrick bought for the gun. Herrick told the gun seller she wanted the weapon for protection, but she testified she really wanted it for suicide. The laser sight doesn't neatly fit with either of those narratives, and I see you shaking your head. So this doesn't surprise either of us that this was one of the things those jurors really keyed in on.
Yeah, why would you get a laser sight to shoot yourself in the head? It's not going to do you much good in that situation. So it makes no sense.
Yeah, okay, I mean, I guess maybe she could say, well, I wanted to convince the guy that I was buying it for protection and that the laser sight would have helped because I'm not a good aim, but that argument I don't think was very well developed.
But if you're buying a gun for protection, you're talking about buying a gun that you're going to whip out of your purse or whip out of a drawer in a moment's notice. You're not going to turn on a laser sight and point it. Now, on the other hand, if you want to shoot someone in the back from the top of the stairs, you might need a laser sight.
Yeah, I think the prosecution argued that very effectively here. Let's talk about the trial strategy, the trial tactics here. Was the screaming and yelling effective?
And during the closing argument?
Yes.
I don't think it was. Now, I see why the defense attorney was upset, because the prosecutor was talking about all of the defenses that they hadn't raised, and I don't know that that's proper. They didn't raise self-defense. They didn't raise this. They didn't raise that, because those are things that you know, they didn't raise an alternate suspect. They didn't raise that someone was out of the country. I mean, I don't know that that's proper argument, because you don't have to raise those things. But the yelling and screaming and the lack of control, and frankly, it had to be upsetting to the jurors. The prosecutors, you know, one of the advantages a prosecutor has in a case is they've got someone to point to. And there's nothing worse than when they start pointing at your client and yelling and screaming how guilty they are. But they can do it a little bit. If it becomes the entire closing argument, the jurors shut down because no one likes getting yelled at.
It's tough for the defense. Stephen, we've got to wrap up for the night. Really appreciate your insight here on the debrief. I'll be back next week here on the Daily Debrief at either 4 or 5, depending on testimony. Up next, Brian Ross Investigates here on the Law&Crime Network. Have a good weekend, folks.